Okay, so let's jump into this. Good evening, and thank you for coming out, or sort of coming out, depending on where you are. This is the Micklin Law Group's webinar series. We hold one every month, usually try to hold one every month, the last Thursday of the month. Today's webinar is What You Don't Know Can Hurt You, Common Misconceptions in New Jersey Divorce. Let me give you a little background of what we're going to do today, how the webinar goes in case this is your first time attending. The webinar is scheduled for 60 minutes. I try my best to keep it within that time frame. Sometimes it's a little shorter, sometimes it's a little longer. But I do my best to try to keep it as short as possible without cutting out any kind of information. It's a one-way communication, so as I was testing before, hopefully you can see the PowerPoint and hear me throughout the presentation. Do my best from time to time to check, see if anybody's typing in case there's any kind of audio problems. I am on a new computer. I reluctantly went from Apple back to Windows, so I'm on a new system. I will be taking questions at the end. I don't like to stop in the middle of the presentation, but I do stay as long as necessary to take all questions. I usually recommend that you type them into the questions part of the panel that should be on the right side of your screen. Type them as they come up to you. They will all be there when I get through with this. I will take as much time as necessary to answer them. If for some reason you end up leaving the webinar before your question is answered, you can always email me or call. You should have all the contact information in the emails that you received regarding this. You'll notice, or you should notice, the PowerPoint is also uploaded to the control panel that you have. So if you're interested, you're able to print the slides. Many of my other webinars will have a lot of laws that are quoted in there. This one doesn't necessarily, but it will have some, so you might be interested in it. This is confidential, so those that are in attendance, I do not believe that you can see anybody else's name. And when you post questions, I believe it's the same way, so you do not need to worry about confidentiality or any kind of exposure while you're here. One last tip that's actually not part of this webinar, but for those, I know there's often people who come out to my webinars regularly. Want to know we also have a divorce and custody support group that I host on average every month, also on the last Wednesday of every month. So it's usually the day before my webinar. It's at my office at 187 Washington Avenue, Nutley, New Jersey. It is open to everybody, absent being an adversary in one of my family law divorce cases, but otherwise everybody is entitled to come. Simply just a forum to share what you're going through, what you've gone through, to hear what others are going through. Sometimes it just helps to know that you're not alone. So there'll be information on my website about that, www.micklinlawgroup.com, and probably in future webinars I'll also talk about it. Let's quickly give you a little information about me in case those who are attending haven't met me or aren't working with me. This is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. A little bit about my background. I'm a member of the New Jersey State Bar, both federal and state courts. I started my career clerking in the Superior Court for the Honorable Eugene Austin. I then went on to do complex commercial litigation with Kessler & Associates for a number of years before I opened my practice, which I think I opened about 2001. When I first opened, I was a general practice attorney, which means I did a little bit of everything. I quickly concentrated my practice, and now I only handle divorce, custody, and family law issues, as is the firm that I had, concentrated solely in those areas also. Moving along, a little bit about me. These are some awards I was fortunate to receive in the years past. There's actually many more I've received since this slide. I've just never bothered to update it. I don't put these here to impress you, but to impress upon you that I do know what I'm talking about. I do care a great deal about helping people uncovering these areas of law. So I put this up so that you can trust in what I'm going to present to you. Now let's look at what I am going to present to you. So what we're going to cover in this webinar, simply two simple topics, I think, or at least I've boiled down to two simple topics. First is where misconceptions arise, or basically how how I think misconceptions arise, what the causes of them are, and what they actually specifically are. And inside of that, I'll give you my thoughts as to why these misconceptions exist. Not that that's necessarily relevant, but sometimes it helps understand. That's just, they're going to be just simply my insights, but there's really no way to know exactly where any of this came from. It's just important to know. All right, so without further ado, let's jump into it. So the first area, where do misconceptions develop? And I think there's two main reasons that lead to the popular misconceptions that I've come across in my practice. The first is there's a lot of information available. Maybe 10, 15, 20 years ago, it was very different. You didn't have the internet, or at least you didn't have the exposure on the internet like you do now. There's so much information and so many resources there between the internet, between websites, social media, just individuals that get up and post, people that are happy and unhappy with the process. Anybody can put up information. There's almost no regulation to the information that's going out there. And there's so much, it's hard to sort through it. The main problems you're going to deal with when you're sorting through all this information, and when I say that, I primarily mean internet, because that's where I think most of us go for information. First of all, a lot of it's incorrect, and you're not going to know that. I tell a lot of my clients, don't go to the internet. Unless you're going to my site, don't go to the internet, because you don't know who's putting up this information, and just because they have a fancy graphic doesn't mean it's accurate or truthful. Second is, even if it is accurate and truthful, it may not be binding in New Jersey. Many states, if not all states, have different laws, varying laws. So just because you find something doesn't mean that it is accurate, doesn't mean it's binding in New Jersey or even applicable to your case. I think the second area that causes a lot of misconception is other people giving advice. I tell my clients, don't go to your friends. Don't go to the internet. Don't go to your friends or your family. I'm sure everybody's trying to be helpful, but the thing about family law, especially divorces, but family law in general, is no two cases are going to be the same. I've been doing this for over 20 years. I got divorced myself. No two cases are the same. You can't make any predictions. I tell my clients, divorces aren't complicated. People are. So you can't trust somebody who may be wanting to be helpful is going to be accurate in their resuscitation and belief about how the process works, especially if they're speaking from personal experience and not legal experience. I just had a phone call yesterday with somebody who was telling me his horror story he heard about some kind of custody issues, where the man was put out of his house, even though he owned it before he was married. He didn't see his children for years, and took him, a couple of years to get it undone. Now, that's a horror story, and it doesn't sound like it's something that's commonly going to happen. I said it's unusual. It's possible it's unusual. Probably had some kind of domestic violence that would have removed him from the house, but it taking years to resolve. Stories like that either sound like there's some information that's missing, or what I call them is they're the McDonald's of family law. And we've all heard that story many years ago now, where somebody sued McDonald's for spilled coffee and got $3 million. So people think this is what the legal system is like, but that's an actual aberration. But you hear only about the aberrations. That's what makes them so popular. So things that you're hearing are more likely not the actual reflection of the law, but the unique or specific aberration that person is dealing with. So enough about where and why we have them. Let's look at what some of them are. First, and probably the most common that I hear, or actually one of the most common, although I'll probably end up saying that throughout the whole webinar because they're all surprisingly very common. First is, I must wait 18 months before I can get divorced. I believe this comes from one of the reasons to be able to get divorced is being physically separated for 18 months. But that doesn't mean that that's the only way to do it. So you can file for divorce in New Jersey under several different reasons, and let me list out some of them here for you. Okay, first, 18-month separation, which again is where this misconception comes from. Extreme mental and physical cruelty, which was probably the most common historically until we got irreconcilable differences, which isn't up here yet. Sexual deviant behavior, probably the least common one that I've seen used. Substance addiction, adultery, abandonment, desertion, institutionalism, imprisonment. Actually, abandonment and desertion is actually really the same thing. Institutionalism, imprisonment, and irreconcilable differences. Now, the thing to know about is, again, you can need to, or not need to, but you can wait 18 months to get divorced because of the 18-month separation. That is not a requirement that you use that ground. The thing is, each divorce has a certain waiting period and a certain proof that you must establish in order to do it. So if you happen to be separated for 18 months, or for some reason that's the way you want to proceed and wait 18 months and separate, you can do it, but you're not required to. The extreme mental and physical cruelty is 3 months. You have to prove there's been some kind of extreme or physically cruel conduct that within 3 months before filing. Sexual deviant behavior, no waiting period, but you must be able to describe in detail the behavior that's causing you to seek a divorce on those grounds. Substance addiction, you must prove it existed in the other spouse, that is, for 12 months or more. Adultery is another one, does not have a waiting period, but you need to be able to establish some modicum of proof, person, location, within a reasonable degree of identification to establish it. Abandonment and desertion is 12 months. That's some have questioned whether or not they can be in the same physical house, like if it's in a two-family, but I think you need to be physically separated. Institutionalism, the individual has been institutionalized for 24 or more months for a drug or some form of addiction. Imprisonment is 18 months, incarceration. And irreconcilable differences, which is our newest one, is 6 months. More commonly, people choose irreconcilable differences. It's one of the shortest waiting periods, but it's easiest to establish. Basically, if you've been married 6 months or more, almost anything can be irreconcilable. You're basically going to only have to testify that your marriage is broken down. It's lasted at least 6 months or more before you filed the complaint, and you're not going to reconcile. So again, that's all you have to say. You don't need to prove anything like you might with extreme mental physical cruelty, which is shorter but more difficult to prove. Before we had irreconcilable differences, extreme mental physical cruelty was easier to establish because the courts wanted to let you get divorced. So they weren't going to hold you to a high level of proof in order to get divorced. But the passing of the irreconcilable differences brought us close to a no-fault state. So that only requires that you have 6 months. And like I said, it can be almost anything. So it's just a lot easier to get divorced now than it had been. But the misconception still exists. Second, if I leave my house, I will abandon it. Again, it's shocking how often I hear the same things over and over again. Which, by the way, I did a webinar on this topic a year or two ago, but I'm updating it now, in case for those that may have attended it before, you see on my website, because some of the laws have changed. So I'm going to speak about that in a few minutes, so it helps to kind of update. This misconception, I believe, originates because of the abandonment issue or the abandonment statute that allows for divorce. So because you can file for a divorce if you've been abandoned for 12 months or more, the term, I think, circulated around people and court papers and media or internet, and it caused people to believe that they're going to lose their house or their children for that matter. But more often I hear about the house. So let me say unequivocally, you do not abandon an asset simply because you move out. Many reasons a person will move out. Living together may be less than favorable. There could be domestic violence. Whatever the reason is, you're certainly free to do it. As I said, it is a reason to file for a divorce, but it doesn't affect the distribution of your assets in any way. But there is one caveat that I thought of after I did the presentation. The distribution of your assets, like of all your assets, including a house, is based on equitable distribution, not equal, which means it's based on what's fair. Now, if you leave your home and you do not contribute to its upkeep, mortgage payments, taxes, repairs, and substantial amount of time passes, or the other person has to invest a substantial amount of money to keep it in good condition, to pay the bills, you may lose some of your interest because you haven't contributed to it. The other person who has been contributing on his or her own may receive a larger share of the asset as a repayment or a recoupment of the investment that was paid when you left, but you do not lose the asset or a claim to its asset. You may just start to lose some of your interest, but if you had been there, you would have been contributing to it. So it really kind of nets itself out to be equal. You may not feel that way, but ultimately, the rule to take from here is that you don't abandon it. You don't lose the interest. Just be aware of the effects that could have. Moving on to prenuptial agreements. People believe that only rich people with a lot of assets need a prenup. I think this comes just because historically that probably was the case. I think the law and divorces were a little less complicated in the past, and I think if you did not have a lot of assets, you didn't have a lot of complications or alimony. Now I think it's very different, and given the nature of women in the workforce, which is very different than it was 30, 40 years ago, blended families, I think it's causing a very big change in prenuptial agreements. I've been telling people and clients for years that they can help all people getting married. I truly think everybody should have a prenup before you get married. It doesn't need to be, I get everything, you get nothing. When we divorce, there's no alimony. You can set out in advance how long alimony will be based on how long you may be married. You can determine how your assets are going to be divided and how you're going to make decisions while you're married. So ultimately, I believe it's a very positive thing for couples, because primarily when you're getting married, you're forced in a prenup to exchange financial information. You have to have full disclosure in order for it to be effective. You need or should have tax returns, credit card statements, appraisals of assets. And this is important because I can't tell you how many people still come to me, and I'm doing this webinar in 2017. I get people who come to me, they've been married for decades, and I'll ask them how much their spouse makes. They have no idea. I'll ask them what assets they have. They have no idea. They have no control over the finances. They don't know what their debts are, if they have credit cards or not. We're still, even though we have more families with two incomes, we still have, more often than not, have one spouse who is a significantly higher wage earner, and we have one spouse that has control over the finances. They're not necessarily always the same people as you might think. Sometimes the person who's out earning all the money, the other spouse is home taking care of all the bills. The one spouse focuses, puts his head in the dirt and works, or his or her, and then the other one's paying the bills. So a lot of people still aren't aware of it. But more importantly, you're outlining your resolutions early. Like I started to allude to, you can determine what your alimony is going to be like. You can determine how the money that you bring in gets divided, or the money that you earn while you're married gets divided. The thing that people don't realize is you do a prenup in the beginning of your relationship when you love and trust one another. When you get divorced, you're facing issues where your relationship is strained, your finances are difficult, and it's an overly emotional process. You want to make decisions that are going to be for the best of you when you care most about one another. That's likely to lead you to the best decisions in the end. It also lets you move on easily, helps you if you're going to be co-parenting after your divorce. It's just having a prenup can accomplish a great deal before, during, and after your marriage. Next misconception. And this is going to be one of two that are kind of related. This one, the first is I cannot get alimony if I was married less than 10 years. Now I'm going to get into just a few details about alimony here because I'm going to get into more later. So the first thing to know about alimony is there really is no set guideline by which your marriage years dictate your alimony years. What meaning, to some extent, it does matter how long you're married, but there's no set guideline. There's no black line that says after X years you get Y years. The purpose of alimony is to assist one spouse who's lost the opportunity to advance during their marriage. It's called economic detriment. Somebody's lost that ability and may not be able to recoup it, or at least needs some time to be able to do so. It's intended to, and this is a term that gets thrown around, lead a comparable lifestyle to that of the marriage. Now, the comparable lifestyle standard has actually been changed a little bit, and we'll talk about the alimony reform in a few minutes and how that affects both, or all alimony issues. But it used to be alimony was to help the lower earning spouse lead a comparable lifestyle. And now the law says the comparable lifestyle should be entitled to both. And that was a very important distinction, because when you look to the lower earning spouse's comparable lifestyle, you were taking that away from the higher earning spouses. And it just led to a lot of unfair decisions. So there are a number of things that a court's supposed to consider, not just the number of years. There's actually 14 different factors. Right now I'm just going to cover a handful of them. But first, I think there's 4 that are most important, not necessarily in the order the slides are going to present it, but the spouse's ability to pay, length of the marriage, age of the parties, marital lifestyle, capabilities, and employability and distribution of marital property. Out of these, I think the equitable distribution of marital property is the least important, the least considered. That's usually only relevant if you have a substantial amount of assets. I think the most important are the ability to pay, the length of the marriage, the marital lifestyle, and the employability. So let me just mark this right here. These 2 and these 2. In my opinion, it's these 4 that the courts will look at most commonly. It's also, I think, the most relevant and most easily to determine. All right, let's move on to the second of the related issues that I mentioned, and this is I can only get permanent alimony after 10 years of marriage. Now, I don't know if maybe the misconception came because people used to talk about not getting it if it was under 10, so that led people to believe that after 10 it was permanent. Some people do believe that there's 1 or 2 kinds, no alimony and permanent alimony. A lot of misconceptions around alimony. These 2 are the most common. I do think they feed off of one another. So, as I said before, no time exists for alimony. There's no set duration or black line rule. I mean, you can, as a matter of course, go basically, the longer the marriage, the more likely you'll receive, and I put permanent alimony, but that's actually, I use that because it's just habit, but we don't technically have permanent alimony anymore. It's called open durational, which we'll talk about in about 30 seconds. But the longer that you're married, the longer your alimony will be, generally speaking, and I think a lot of people operate under these assumptions. Not necessarily the case, but it's kind of a guideline most people go through. Again, the alimony, the courts can consider a number of issues. These are the same as before. They're not all of them. I'll go through all of them in a minute. But I wanted just to touch on when we're talking about these 2 issues, just to revisit the considerations. Now let's talk about the alimony reform laws. And it really relates to not only both misconceptions, but the overall alimony issues, because there were a lot of problems with the way alimony was handled. I still think there are a lot of problems with the way alimony was handled. The reform made some stricter rules for alimony, but I don't think it really settled all the issues that we have. But one of the main things it did do was took away permanent alimony and called it durational alimony. I mean, the ironic thing is I don't think durational is a word, which is embarrassing for the legislature. But so the standard for time-wise now, they said, is that alimony can not be any longer than the length of your marriage if your marriage is less than 20 years. And this is an important phrase, or important issue. It hasn't come to bear as an issue yet, but what I think is going to happen is when people read this, they assume if it's more than 20 years, then you can get more than 20 years. But it only speaks about being less than 20 years. And a common rule of interpretation is if the legislature intended it to mean something, they would have said it that way. So here they only said it can't be longer than the marriage if less than 20. That does not mean if it's more than 20, it can be more than 20. So it's an issue I think is going to be coming up in years to come when the new, I still call it the new Alimony statute, although it's been a number of years, when the reformed Alimony statute starts making its way up to the appellate division for decisions. All right, so enough about money. Next misconception is about legal separation. So again, let me be very unequivocally clear. New Jersey does not recognize legal separation. Now, I'm going to go into a couple potential caveats to that, but as a rule, there's no such thing as legal separation. Don't ask for it. Don't expect to get it. Maybe other states have it, which is what causes it to be a misconception here, but New Jersey does not. What Jersey does have is something called a divorce from bed and board. That is a limited divorce. It resolves the financial issues, but doesn't actually sever your marital contract. So in theory, you're still married when you're done, but your finances and your custody issues have been resolved. You can then petition at any point, I think it is now in the future, to make the limited divorce a complete or final divorce. The issue inside of that is you have to understand that you're still married, so that, for instance, you can't remarry. And a lot of people may not actually understand that. And again, it's not a legal separation, because when people talk of legal separation, they mean some way to just separate and be married, but have your finances resolved, which sounds like divorce from bed and board. But divorce from bed and board is a legal formal process. And I think the intention when people speak of legal separation is to have an informal separation that is legal, and we don't have that. The reason that people do limited divorce is either they're very religious historically, they couldn't get a divorce, and other people who need to continue medical coverage and one can still be considered the same family. So you're not actually divorced. When you're divorced, you can't be on a family plan. The interesting thing about this now is, at least from the insurance standpoint, I've been finding a lot of insurance companies are catching on to this and are starting to deny coverage for those that are limited divorce or divorce in bed and board. So I've had some cases recently where we've had to do it, not had to, but we've done a bed and board. And I was checked with the insurance companies that they will honor that. And we put in our agreement that it's based upon the statements that the insurance company will honor it. I also put in our agreements in the event that that should change, that we would have, depending on which side I'm on, we would have the ability to revisit the issue in the event the insurance companies change their policy or the person changes insurance companies. Could be somebody else. Now, here's one caveat that kind of floats around the back of my mind when this issue comes up. And that is the issuance of a final restraining order in New Jersey, or even actually a temporary restraining order for that matter. A final restraining order does physically separate you and is a legal document or a legal court order that keeps you physically apart from contact and often from communication. I've had some clients who have believed and tried to argue, for instance, like to the Internal Revenue Service, for instance, that they were legally separated by a final restraining order. And I think actually it may be allowed under certain circumstances when it comes to the federal tax filing. And other states may have it. But again, New Jersey doesn't consider it a legal separation. They consider it a final restraining order. Never heard the term commingled in any sense. So I don't consider that to be one. And it's certainly not what people are talking about when they ask about legal separation. Now, a way to do legal separation that can accomplish what people are often looking for, and that is an informal way to separate and resolve finances, is with a postnuptial agreement. A postnup is just like a prenup, except it's done after you're married. The purpose of it is to, like I said, resolve your financial issues, leave yourself married. It's a little less formal, so you don't have to file anything with the court. The problem with a postnup is it's a contract. Well, there's a lot of problems. So first of all, it's a contract. Being a contract, like any contract, it's only as good as the people who sign it. You can lease a car, and if you don't want to pay the premium, or you don't make the lease payments, you have to repossess it. It's complicated. So you have to first trust that the people that are signing it are going to be willing to be bound by it. The second issue becomes, how do you enforce it? To one extent, it's a family agreement, family law matter agreement, but it's not a family court matter. There's no postnuptial enforcement in a New Jersey court, which could lead you to have to file in the family court, or I'm sorry, in the civil court as a breach of contract, which is a much more complex court system and process. And the remedies that you may want may not be available in civil court. So it's a very complicated, sort of messy option that I only recommend to people who really seem to work together, have maybe common goals that they're trying to achieve through this post-nup. Otherwise, it's very difficult. And the law doesn't favor them right now. Where a prenup is, in the simplest form, valid as long as it's got the proper elements to it. It's not considered, in my experience with judges, to be coercive or unfair in and of itself. The law about postnups indicate that the courts view postnups as much more coercive than a prenup. They believe it's sign this or we will get divorced, or I'm leaving you. Now, I personally don't agree with this, and I never have. I think a prenup much more coercive because it's sign this or the marriage is off, and there's a lot invested. I think people are more likely to call off a wedding because of an agreement that they can sign than to go file for a divorce because they can't get an agreement signed. Divorce is a difficult process that 9 out of 10 people that come to me asking about it don't file it simply because they're afraid of it. So, well, that's my soapbox. I disagree with the current law on the issue, but I don't make them. So what you need to know is that they are coercive, and that's something you need to factor into your decision whether or not to have or not have one. Next misconception is, and this is an important one to pay attention to if you have children, is a custodial parent cannot leave the state without the other parent's permission. Now, I'm generally going to be speaking about a temporary removal, meaning a day trip to New York, a weekend trip to Canada, not moving out of the state, which would be a relocation case. The law is very different. The standard is very different. Now, the misconception applies to both, but I'm only talking about the misconception as it relates to not being able to go to New York for a day trip or fly on vacation. So first of all, and this is what it's hard for a lot of people to accept, you can leave the state with your child, even permanently, if custody is not an issue. And this is a very important term to listen to and to understand. Custody is an issue if it has ever been an issue in any court proceeding at any time in New Jersey. Meaning, if you have ever had a case for child support, for parenting time, for custody, for DCP&P, if you've ever filed for divorce, domestic violence possibly, restraining orders. Orders that result from these cases mean that custody has been an issue. It may not be an issue, it is not currently an issue, but it was an issue. If it ever was an issue in a case, then it continues to be one. And I'm stressing that because I don't want people to misunderstand what I'm saying and just think they could pick up and move because they only dealt with child support and not custody. Child support makes custody an issue. Anytime there's a rule that you want to go by, if you've ever been in court in any matter about your family or your children, custody has been an issue and therefore you cannot leave the state. But if you've never been in the court, you've never filed, you're just not happy, whatever it may be, you are entitled to leave the state without the other parent's permission. I don't necessarily recommend it if it's going to be a permanent thing, just from a parenting and a sort of an equity issue that I don't think you should just take off, absent compelling circumstances. But the point of my role as a lawyer is to tell you what the law is, and the law says you can, but so long as you've never had custody, parenting time, or child support issues. Now, if you can't get the other person's permission and you want to leave, it doesn't mean you can't. If you've had an issue and you can't get, or if you've had custody as an issue, and you can't get your other parent's permission, then you have to go to court and get the court's permission. And depending on the type of custody arrangement that you have, whether it's equal shared time, physical time, who is custodial parent, will determine what you may need to show. Like I said, it's going to also vary on the nature of the removal. If it's going to be an extended vacation, you're going for a week, it's a lot more, it's a lot lower of a burden to prove. Even if you're traveling out of the country, usually you just need to show an itinerary, the return trip, so that they know you're coming back. The only times that these issues I see get complicated at all is if there's been past real issues of parental alienation or interference. if you or one of the parents maybe left and had to be compelled to return, that could affect even a simple request to travel, even if it's just out of state for the day. It's also an issue I'm not getting into here about the Hague Convention, but for those that are worried about international travel and international, I say kidnapping, even though technically you can't kidnap your own child, but if you're worried about that, you want to look into the Hague Convention and which countries are and are not members or signatories of that convention. Not something for today. What I want you to take from this is, if you've had custody as an issue, you can't leave without permission. If you've never had it as an issue, you can, but you might not want to. Next is common law marriage, because I've been together for 10 years. And this is sort of like the earlier one, that slips my mind what I was talking about, that I think comes from usage. And that would be legal separation. Common law marriage along with legal separation, I think, originate as a misconception because there either are jurisdictions that acknowledge it, and in some cases, New Jersey may have historically, but no longer. So common law marriage definition is two people living together as husband and wife for a specific amount of time. And I think it's a broad brush, but I think that would mean something a little more specific. Like living together as husband and wife, I think you'd have to have joint expenses, shared responsibilities. I think you would have needed to hold yourself out as a married couple, as husband and wife, whether it's on social media or in your community. And that's only in the states that may recognize it. New Jersey does not. The interesting thing was, I think they did, but it had been abolished some time ago, and that could also lead to why people still believe it. I don't think that's the case. I don't find people well versed in the history of the law. Even lawyers aren't often well versed in it. I think it's just because some states do, and that causes us to think that New Jersey will. Now, an interesting thing is that there could be states, I believe there are states that have it. So if you have a common law marriage in another state, it may be enforceable in New Jersey because New Jersey, all states in some respect, have an obligation to follow and respect and adhere to the laws of other states. It's never an issue that I've actually dealt with. I've never had the attempt to try to enforce a common law marriage from another jurisdiction in New Jersey. My belief is that it would not likely be successful because the law in New Jersey is very clear. So, moving on to what I believe is our last popular, I hate to say popular, but I guess common misconception is that you cannot get alimony if you've committed adultery. And as much as a lot of people would love for that to be the case, it's unfortunately not. So no matter what horrible thing that other person may have done, it's not likely to affect alimony. Now here's where I'm going to take a few minutes. I'm not going to read them all out, but I am going to talk about the 14 different criteria so that you have them. Again, if you want to print out the handout, if you've gotten enough from the webinar, you don't need to stay around from it because this is our last one. The rule simply is that does not necessarily affect it. At the end, I'm going to get into a little bit of a caveat, but just hold tight. So need and ability to pay, duration of the marriage, age and health, standard of living. These are all the same from before. Earning capabilities, employability, like we said, length of absence from the job market. This was not here. Again, this goes to the economic detriment that I was talking about, which is the underlying policy of alimony. Parental responsibilities for children, time and expenses to raise or acquire sufficient education. This is usually going to be for something called rehabilitative alimony, which is one of the few, not many, but few types of alimony that I'm not going to get into in the scope of this, but I did do a webinar, I think, previously on the different types of alimony, which will be on my website, nicholandlawgroup.com. History and contributions of the parties, that comes into effect if maybe there was a significant contribution of one or a significantly a contribution of assets or even a significant contribution to debts that have accrued in the marriage can sometimes lead to a different amount of alimony being awarded. Distribution of property and debts, as I said in the beginning, this I find to be the least utilized aspect. I think it's only going to be for parties that have a significant amount of assets, as is this one. Income that's available through other assets. So if you have a trust, may or may not be important, but if you're getting income from that, tax consequences now of that income as well as the alimony award is considered. One of the new factors under the new reform statute is the nature and amount of pudendum lite support. Pudendum lite support is support that is ordered while your divorce is pending. Before the alimony reform, it did not affect the length of alimony. So if you're married 1 year and your divorce lasted 3 years and you got temporary support for 3 years, it didn't matter. You could still get alimony. That's now changed. So the temporary support or pudendum lite support amount of time is factored into the amount of alimony, which brings us back to the fact that the law caps alimony more than 20 years if you haven't been married for more than 20 years. So it's just helpful now that that temporary period is also counted into your alimony work. Now, lastly, what all good statutes in New Jersey have is a catch-all. So there's any other factors that the court may be relevant. The court may be relevant. And here's the caveat that I was talking about. It is possible that a court could use adultery as another factor that's relevant. I believe there's even maybe a case in New Jersey that had decided at one time. I'm not familiar with it now offhand because it's so uncommon. I think theoretically, the only time that this factor would be utilized, and truthfully, the only time alimony or adultery would ever affect an actual alimony decision, is if the nature of the adultery affected the financial aspects of the marriage or the parties. If, for instance, the other spouse, upon learning of it, was so emotionally distraught that he or she is now handicapped or unable to work, then that person would be a candidate for alimony, and it may be due to the actions of the adulteress. So it'll be something like that. But the statute doesn't say it, and like I said before, historically, if they intended it to be there, they would have written it there, and the argument generally is since it wasn't written there, it wasn't intended to be there. Other than my possible exception, which I've never ever seen play out of itself, I don't think it would ever actually become a factor, and I think it will remain a misconception. That is the end. I'm going to first launch some polls just to take get some quick information from you so I can see if this is helpful or not. Then we'll go to any questions that you may have. Must be closed. Okay, so I think you can see the poll, hopefully, and I can't. So when I close it, I get to share the responses. So all right, so it looks like half and half, and internet and email. Next, these are only going to take a second. Is this a good time for these webinars? Now, I used to do these at 6:30, but I felt that some people had trouble getting home from work to a computer at that, so I pushed it back to 7 o'clock. Just going to give another second or two for some, get some results in, and we'll move on. All right, so it appears that this is a good time, so I'm going to keep it that way. Moving along, I think I got two more, and then we'll move on to questions. Those that may not have written questions during it, now's a good time to maybe quickly jot down any questions that we have. Next question should be up. This is strange. Usually I would see these polls, and this time I'm not, so. Even though this is confidential, I'm not going to share that post. Now, it's important for me to know even though I didn't get to your questions, the purpose of this poll is to make sure that the material at least covered what you were expecting to hear. I know I have a question or two pending, so I'll get to that too. All right, so some said I don't know, and some said no. I do have one question posted, so those that have posted that they don't know are free to email me if you don't get a chance to put a question up now that I can answer. But whatever question that you still do have, I will absolutely address it if you can contact me one way or another. And here is just if there's any further advice I can give on a one-on-one basis, let me know here. I will not be sharing this result either. Okay, so the polls are now closed. I will look to the questions. I think there's actually only one. Of course, we usually only start with one, and then I get some more. All right, so first question I have is, I'm going to read it out just to make sure that it's clear. What if I am separately living for a year and both parties living on their own, and then I move to an alimony-free state like Michigan? Then I file for divorce. And questions about alimony are very difficult to answer because there are so many factors that contribute to it. So I'm going to try to answer this question with explaining what my assumptions are inside of the question, so that in the event your circumstances are different, my answer may be different. But I'm going to go on the assumption that you lived in New Jersey for a substantial amount of time, or that you were married in New Jersey for a substantial amount of time, separated and lived separately in New Jersey, and then one of you moved to a state like Michigan that doesn't have alimony. It is possible that that state would not grant alimony, but I think it's unlikely. There's a body of law in all states. It's called conflicts of law. Conflicts of law addresses issues when multiple states are involved. And the law school example that you get is, a New Jersey resident boards a plane in Pennsylvania that was built in Florida that crashes in Utah. Whose state law is going to apply in this lawsuit? So and the simple version of conflicts of law is that the state with the most contacts and the most interest will apply. So in your circumstance, under the assumptions that I listed, I believe Michigan, or at least if I was defending this and I was trying to fight for alimony, I believe Michigan would be the forum that holds your divorce, but they would use New Jersey law because New Jersey is the state that has the most interest. Your marriage was here, your history was here, your assets and debts, and the right to acquire or to have alimony awarded arose in New Jersey. So New Jersey would have an interest not only in protecting its citizens, but having its law upheld. And the public policy against forum choosing, forum shopping, which means going to another state just to get good law, works against you. So the short answer is I don't think if there's going to be attorneys involved that move is going to be successful. Next question, which I think was raised by the same person, so it may have similar facts and issues. Let me just take a sip of water. What if I'm living separately, have a post-nup, then file for a divorce after 1 year of living separately? Does that status quo become harder to fight by my spouse, or my inherited funds subject to my spouse trying to prove more alimony? Okay, so there's a couple things in here, a couple different questions. So let me break it down. What if I'm living separately and have a prenup or a post-nup, and then file for a divorce after 1 year and living separately? Does the status quo become harder to fight? Well, that's hard to answer because the post-nup could be considered a settlement agreement, and that would likely be enforceable if it was fair and reasonable. So I'm not sure what you mean by the status quo. I don't know if you mean the year of separation being the status quo or the post-separation being the status quo being harder to fight. But I think if the agreement was fair, that it would likely be upheld, and you could enforce it. I would enforce it as a settlement agreement, not a post-nuptial, because a settlement agreement is how most divorces are ended. Sometimes we do them in the very beginning to reduce the litigation. So a settlement agreement that's signed is binding, and the public policy is for the courts to uphold them, not to overturn them. So I think that your post-nup should be held up, but it depends how quickly you file for divorce after. Are my inherited funds subject to my spouse trying to prove more alimony? It depends. Your inherited funds are exempt from equitable distribution so that your spouse will not share in them, but income that you receive from that and your ability to draw down from any principal goes to your ability to pay, which is one of the main factors. So the answer to that is probably yes, that your inherited funds could help your spouse prove more alimony. Next question. If you think your spouse is a psychopath, can you ask the court to have them take a psychological test? If there's children involved, yes. If there's not children involved, probably not. Hopefully the reasons are obvious. If there's children involved, the courts have a significant concern for making sure that children are cared for properly. If you're not sharing children or co-parenting, once you're divorced, there's little reason why you'd be forced to have any future contact. There's no harm the court needs to protect you from, so I don't think the court would order the psychological evaluation. Plus, it opens up a door of abuse and misuse by the other spouse. So I don't think a court would do that absent a custody issue or some other fact that I'm not aware of in the future of the two divorcing parties. All right, so let me see. I think there's another one or two here. All right, so the next one, status quo is that there is no alimony to be paid, everything else divided half. Status quo is, I believe this might be related to the post-nup question when I said what is the status quo. So status quo is that there's no alimony. I'm assuming you mean by status quo under the post-nuptial agreement is that there's no alimony and everything is divided half and half. I think a court would uphold that. I think the ability to pay being one of the important factors and the other spouse's ability to earn being the second most important factor. If you've been living under arrangement for a year or more where the one spouse has not needed or requested alimony, signed an agreement saying that he or she did not need or want alimony, I think that a court may be inclined to conclude that there should not be alimony in a case like that. I hope I'm answering the questions the right way. I hope my assumptions are relatively accurate. I'm trying to base them on what I'm accustomed to hearing, so what I assume is being said is what I'm basing my answers on. If the assumptions or the facts are very different, like I said, my answer may be very different. Willing to wait. I don't see any other questions. I'm going to hang on for another few seconds in case there are any questions. If you think of some when I sign off, again, you should have my email from your registration. You can certainly email me. My phone number is on the bottom. The email on the bottom, the info at Micklin Law Group, don't use that one. Use brad@micklinlawgroup.com. That'll come directly to me. That should probably be on the one that you received as part of the confirmation. But the info will get to me. It just takes longer, and it goes to another staff member, so I'd rather just come directly. All right, so I got another comment about the status quo. It says, assumptions are correct, good. Post-nup says pay $800 a month until divorce. Well, now that sounds like an alimony payment, where I was saying that I thought you were indicating the post-nup did not have an alimony, the person was living without alimony. Now it sounds like they are living with alimony, and the post-nup says at the divorce they don't get it. That may change my answer, because remember I was saying earlier that in my experience, post-nuptials are frowned upon and found to be coercive. So if a person who under that agreement gets alimony because there's a need for alimony, it'll be compelling to say, I was forced to sign that because I needed the alimony, but I can't live without it afterwards. But I can't be certain. I don't really know what went into the signing of the prenup, or I'm sorry, the postnup. I don't know if the facts of your marriage suggest that maybe 1 year is good. You can also argue that if the agreement, the postnup, is overturned or discarded, that at least consider that as part of a Penene Lite award so that it goes into the final term. But I don't know. My gut would still say if it's a short-term marriage and not a lot of income on either side, it may still be upheld. It may be deemed to be a fair agreement, but without knowing more about the circumstance and the agreement, it's hard for me to answer with certainty. So I'm sorry to backpedal on that question or those questions, but I'm just not sure, and it's a very complicated area. Follow-up question about the psychological test is who would pay for it. If, again, it goes to the reasons for it. If there were custody issues and there was a genuine request, meaning it doesn't appear to be motivated by bad faith or ulterior motives, I think the parties would probably split the cost of it, or unless there were some assets and it would be paid from a joint asset. If there was no compelling reason to do it, but the court was either inclined to grant it or one of the parties was agreeing to do it because it would facilitate getting divorced, then I think the person requesting the test would be the one who pays for it. That's what equity would suggest. I'm going to double check, make sure I didn't miss any questions here. Okay, so I don't see any new questions other than the last one or two. I'll wait, like I said, a few more seconds in case something pops up. All right, so that's going to conclude our webinar. I believe my next one is going to be, I'm actually not sure. I hate to say it, because it would normally be the 26th, but I'm out of the office, I believe, that week. So, but go to my website, micklinlawgroup.com. It will have the dates for my next support group and for my next webinar. You may want to check it in a couple days because we did have to do some rescheduling because of my trip in October. It takes me out of the office, and then in November, obviously, is Thanksgiving towards the end. So go to the website. You can always call my office, but the dates should be up there. Just check them, I'd say, in about a week to make sure they're active. With that, I thank you for coming out, listening to me, giving me your time in the evening. I'm sure you had a million other things that you needed to do. I hope this was helpful to you and hope to sort of see you at our future webinars. Have a good night.